The federal courtroom fell into stunned silence as retired Supreme Court Justice Stephen G. Breyer, serving temporarily on the District Court for the District of Columbia, delivered his ruling. The 85-year-old jurist voice echoed through the chamber with uncharacteristic severity as he stared down at Congresswoman Jasmine Crockett from his elevated bench. For deliberate and repeated violations of this court's confidentiality order, Justice Breyer declared, his Harvard-educated diction precise and cutting, the defendant, Representative Jasmine Crockett, is hereby fined $2 billion payable to the Treasury within 30 days. The gallery erupted in shocked gasps. Court reporters stopped typing, certain they had misheard $2 billion. Even the Justice Department. Attorneys looked stunned by the unprecedented penalty imposed on a sitting member of Congress for simply discussing voter suppression statistics during a CNN interview while a federal case was pending. Congresswoman Crockett, the former civil rights attorney now representing Texas's 30th District, remained perfectly composed, her expression revealing nothing. As Justice Breyer continued his uncharacteristic rebuke about congressional interference and undermining judicial independence, her legal team frantically shuffled papers, preparing for an immediate appeal. But Crockett calmly placed her hand on her lead attorney's arm, signaling him to wait. She stood slowly, straightened her crimson blazer, and approached the podium with the measured confidence of someone who had faced impossible odds before and prevailed. The packed courtroom collectively held its breath, wondering how anyone could respond to such a clearly disproportionate penalty from one of America's most respected judicial figures. "Your Honor," Crockett began, her voice steady and clear, "I request permission to address the court regarding your ruling." Justice Breyer nodded curtly. "You may proceed, Congresswoman, though I must say my decision is final." What happened in the next 4 minutes would not only reverse the outrageous fine, but would fundamentally transform the national conversation about the separation of powers, free speech, and the constitutional duty of elected representatives to speak truth even when courts prefer silence. Before we reveal the response that left Justice Breyer openly weeping and apologizing before a stunned courtroom, please take a moment to like and subscribe to our channel for more powerful stories of courage in the face of authority. Your support helps us continue bringing you these extraordinary moments when constitutional principles triumph against all odds. To understand the full magnitude of this confrontation, we must recognize the remarkable backgrounds of these two distinguished public servants whose different perspectives on constitutional principles had placed them on an unexpected collision course. Justice Stephen G. Breyer had devoted his life to public service and the law. After graduating from Stanford, Oxford, and Harvard Law School, he had clerked for Supreme Court Justice Arthur Goldberg before building an illustrious career that included teaching at Harvard Law School, serving as chief counsel to the Senate Judiciary Committee, and 13 years as a judge on the First Circuit Court of Appeals. In 1994, President Clinton appointed him to the Supreme Court, where he served with distinction until his retirement in 2022 at 85. Breyer remained active in the federal judiciary through the little-known senior status program that allowed retired Supreme Court justices to serve temporarily on lower federal courts, known for his pragmatic approach to constitutional interpretation and belief in active liberty. Breyer had written extensively about the importance of considering the real consequences of legal decisions. Throughout his career, Breyer had been respected for his intellectual rigor, his ability to build consensus, and his commitment to protecting democratic institutions. His written opinions were characterized by detailed analysis of how laws worked in practice rather than abstract theory. Liberal in his judicial philosophy, but moderate in temperament, he had always emphasized the importance of maintaining public confidence in the judiciary. What few people understood was the personal toll that recent political attacks on the court, the system had taken on Justice Breyer. In his final years on the Supreme Court, he had watched public confidence in the judiciary plummet as politics increasingly influenced perceptions of judicial decisions. Since retirement, he had become increasingly concerned about what he viewed as congressional encroachment on judicial independence, particularly when elected officials criticized court decisions or ongoing cases. Across the courtroom stood Congresswoman Jasmine Crockett, whose path to public service reflected a different kind of commitment to constitutional principles. At 43, She represented a new generation of leaders who combined deep legal expertise with lived experience of the issues they legislated. Before her election to Congress in 2022, Crockett had built her reputation as a formidable civil rights attorney in Texas, taking on police brutality cases and fighting for voting rights. The daughter of a military family, Crockett had worked her way through Rhodes College and the University of Houston Law Center. As a state representative in Texas before her election to Congress, she had gained national attention for her impassioned defense of voting rights during contentious legislative sessions in Congress. She had quickly established herself as an outspoken member of the House Judiciary Committee, particularly on issues of constitutional rights and election integrity. Unlike many in Congress who relied on staff to understand complex legal matters, Crockett brought first-hand knowledge from her experience litigating civil rights cases in federal court. She had argued before numerous federal judges and had developed a reputation for meticulous preparation and strategic legal thinking. Her academic understanding of constitutional principles was matched by practical experience, representing communities directly affected by voting restrictions. The conflict between Justice Breyer and Congresswoman Crockett had begun 3 months earlier during a high-profile case challenging new state voting restrictions in Texas, Georgia, and Arizona. As these cases moved through the federal courts, Justice Breyer had been temporarily assigned to the D.C. Circuit to help with the backlog of cases and through the court's random assignment process, had been given this politically sensitive matter. Recognizing the case's importance, Breyer had issued a confidentiality order restricting public comments by all parties while the case was pending. The order was unusually broad, effectively prohibiting even members of Congress from discussing general voting rights, statistics, or patterns of voter suppression that might influence public opinion about the matters before the court. Legal scholars immediately questioned whether such an order could constitutionally apply to elected representatives discussing matters of public policy relevant to their legislative duties. The First Amendment implications were significant, particularly given the speech or debate clause of the Constitution, which provides special protections for congressional speech related to legislative activities. The confrontation escalated when Crockett appeared on CNN's State of the Union to discuss a Congressional Black Caucus report on voting access. When asked about statistical disparities in polling place closures, she cited publicly available data showing that, since 2013, over 1,600 polling locations had been closed in areas with historically significant Black and Latino populations, though she carefully avoided mentioning the pending case or Justice Breyer's order. The Justice Department immediately filed a motion claiming her statistics undermined the court's authority by indirectly influencing public perception of the issues. In the case, Justice Breyer scheduled an emergency hearing, leading to this unprecedented moment of constitutional confrontation between two public servants who had each devoted their lives to upholding the law as they understood it. The federal courtroom was filled to capacity on the morning of the contempt hearing. Legal observers, congressional staff, and media representatives packed the gallery, while a line of people hoping for admission stretched down the hallway and out of the building. The case had taken on enormous significance, recognized by all as a potential landmark in defining the boundaries between judicial authority and congressional speech. Justice Breyer entered promptly at 9 a.m., his slight frame still carried the dignified bearing developed over decades on the nation's highest court. The assembled crowd noted that, instead of the district court's typical black robe, Breyer wore the more formal attire associated with the Supreme Court, perhaps unconsciously, signaling the constitutional weight of the proceedings. This court will come to order. The clerk announced as everyone rose. After the formalities concluded, Justice Breyer addressed the matter directly. "We are here today to address the department's motion regarding Representative Crockett's alleged violation of this court's confidentiality order. Mr. Mitchell, you may proceed with the government's position." The Justice Department attorney rose from his table. "Thank you, Your Honor. The government contends that Representative Crockett's statements on CNN directly violated your order, prohibiting public discussion of matters related to this case. By citing statistics about polling place closures in minority communities, she clearly intended to influence public opinion about the very issues before this court." Justice Breyer nodded. "And what remedy does the government seek?" Given the deliberate nature of the violation and Representative Crockett's legal background, which means she fully understood the implications of her actions, we ask the court to impose a significant sanction. We suggest a fine of $25,000 and a clear warning that further violations will result in more severe consequences. Justice Breyer turned to Crockett's attorney. Counsel, your response. Crockett's attorney, a distinguished civil rights lawyer named Marcus Washington, rose slowly. Your Honor, we maintain that the Congresswoman's statements fall well within her constitutional rights as an elected representative. She discussed publicly available data relevant to her legislative duties without referencing this case or your order. Furthermore, the speech or debate clause provides constitutional protection for congressional speech related to legislative activities. Before Washington could continue, Justice Breyer interrupted, his tone uncharacteristically sharp. Counsel, are you suggesting that members of Congress are somehow exempt from court orders? That they can simply ignore judicial directives if they find them inconvenient to their political messaging? The question revealed an unusual edge to Breyer's typically measured judicial demeanor. Washington appeared momentarily taken aback by the hostility in the justice's tone. Not at all, Your Honor. We are simply arguing that the confidentiality order, as applied to a member of Congress discussing general policy matters relevant to pending legislation, exceeds the court's authority under the Constitution's separation of powers. Justice Breyer leaned forward. And who determines the limits of this court's authority, counsel? The Congresswoman? Washington maintained his composure. The Constitution itself establishes those boundaries, Your Honor, as interpreted by the Supreme Court in cases like Gravel v. United States, which recognize special protections for legislative speech. For the next 30 minutes, the legal arguments continued, with Justice Breyer growing increasingly impatient with Washington's constitutional objections. Legal observers in the gallery exchanged concerned glances, unaccustomed to seeing the normally measured Breyer display such open frustration with arguments about constitutional limitations on judicial power. Finally, Justice Breyer turned to Congresswoman Crockett herself. Representative Crockett, do you wish to address the court directly before I rule on this matter? Crockett rose with calm dignity. Yes, Your Honor, I would. As she approached the podium, the courtroom fell completely silent. Even the court reporter seemed to pause, sensing the historical significance of the moment. Justice Breyer, she began. Using his Supreme Court title rather than his current district court designation, I have respected your jurisprudence throughout my legal career, your opinions on active liberty and the practical applications of constitutional principles helped shape my understanding of the law. Breyer's expression softened slightly at this acknowledgement of his judicial philosophy. That is why I find today's proceedings so troubling, Crockett continued. The confidentiality order at issue extends beyond any reasonable interpretation of judicial authority. Under our constitutional system, it effectively prevents an elected representative from discussing statistical facts relevant to ongoing legislation, facts available in the public domain and crucial to my constitutional duties. She paused, making direct eye contact with Breyer. As you yourself wrote in your book, Active Liberty, the Constitution must be interpreted in light of its democratic nature, with awareness of the practical consequences of judicial decisions. On democratic participation, the reference to his own scholarly work seemed to catch Breyer off guard. The practical consequence of this order, if upheld, would be to silence congressional speech on matters of profound public importance whenever related litigation is pending. Given the perpetual nature of voting rights litigation, effectively remove an entire category of public policy from representative debate. Crockett's tone remained respectful but firm as she built her constitutional case. The speech or debate clause exists precisely to prevent this kind of judicial constraint on legislative speech, as the Supreme Court recognized in United States v. Johnson. It serves as an important protection of the independence and integrity of the legislature. She then shifted to the specific CNN interview at issue. I carefully limited my comments to citing publicly available Census Bureau statistics relevant to legislation currently before the House Judiciary Committee. I made no reference to this case, this court, or your order. I discussed general patterns that any researcher, journalist, or citizen could identify from public records. Justice Breyer interrupted, his voice now bearing an unmistakable edge. Yet you knew these statistics were directly relevant to the claims in this case. You knew your comments would shape public perception of the issues before this court. With respect, Justice Breyer-Crockett responded without hesitation. Every significant civil rights case involves matters of public policy that elected representatives have not only the right but the duty to address. If courts could silence legislative speech whenever it might influence perception of pending cases, the judiciary would effectively control public discourse on the most important issues facing our democracy. The gallery remained absolutely silent as Crockett continued building her case, citing specific Supreme Court precedents, many from opinions Breyer himself had joined or authored regarding the limits of judicial authority and the essential role of congressional speech in a functioning democracy. As she concluded her initial argument, Justice Breyer appeared increasingly uncomfortable, shifting in his seat and removing his glasses to rub the bridge of his nose, a gesture many who had observed his Supreme Court career recognized as a sign of internal conflict. But when he spoke again, his voice carried unexpected severity. Representative Crockett, while I appreciate your constitutional arguments, this court finds that you knowingly violated a valid judicial order. Your legal background makes this violation particularly egregious. You chose to place yourself above the rule of law. The room tensed as Breyer's tone hardened further. This court cannot allow such blatant disregard for judicial authority, particularly from a member of Congress who should be modeling respect for our constitutional separation of powers. Then came the shocking pronouncement. For deliberate and repeated violations of this court's confidentiality order, the defendant, Representative Jasmine Crockett, the amount was so outlandish, so completely divorced from any legal precedent, that many in the courtroom thought they had misheard. $2 billion. The largest contempt fine in American judicial history had been a fraction of that amount. The gallery erupted in shocked whispers. Court reporters looked at each other in disbelief. Even the Justice Department attorneys appeared stunned by the severity of the sanction. It was at this moment that Crockett stood to deliver the response that would transform the confrontation from a legal dispute into a defining constitutional moment. Your Honor, Crockett began, her voice steady despite the extraordinary sanction just imposed. Before addressing the substance of your ruling, I'd like to confirm a point of constitutional fact. Are you asserting that Article III courts have the authority to prevent members of Congress from discussing public policy matters relevant to pending legislation? Justice Breyer appeared momentarily thrown by the calm, substantive question, in the face of a ruinous fine. This isn't about preventing policy discussions, Representative. This is about enforcing a valid court order that you deliberately violated. The fine you've imposed, $2 billion, is larger than the entire annual budget of the federal judiciary. It's approximately 10 million times my congressional salary. She paused, allowing the absurdity of the amount to register with everyone in the courtroom. Such an extraordinary sanction raises fundamental questions about proportionality, due process, and the limits of judicial power under Article III. But more importantly, it reveals something profound about this moment in our constitutional history. Crockett's tone shifted, becoming both more personal and more powerful. Justice Breyer, I've studied your jurisprudence for years. You've been a champion of practical wisdom in constitutional interpretation. You've argued persuasively that we must consider how legal principles function in the real world. Today, I'm asking you to apply that same wisdom to this situation. She reached into her briefcase and removed a worn, leather-bound book. This is my personal copy of your book, Making Our Democracy Work. I've carried it with me since law school. In it, you write that judicial authority ultimately depends on public confidence that courts will interpret and apply the law fairly. The courtroom was completely silent now, all eyes moving between Crockett and Justice Breyer, who had visibly stiffened at the sight of his own book in her hands. You also wrote, Crockett continued, her voice softening, that judges must consider how their decisions will be understood by ordinary citizens. How will ordinary Americans understand a $2 billion fine imposed on an elected representative? For citing public statistics about voting access, what will this do to public confidence in judicial impartiality? She carefully placed the book on the podium before her. Justice Breyer, I believe in the Constitution you've spent your life defending. I believe in the separation of powers, in judicial independence, and in the rule of law. That's why I cannot accept a ruling that fundamentally undermines these principles." Crockett then turned to address the full courtroom, her voice taking on the resonant quality that had made her a powerful advocate in both courtrooms and Congress. "The Constitution does not permit any branch of government to silence another. My oath, as a member of Congress, requires me to speak truth about matters affecting my constituents, particularly their fundamental right to vote." She turned back to Justice Breyer, who was now watching her with an expression of growing discomfort. "Your oath, Justice Breyer, requires you to uphold the very constitutional limitations on judicial power that your ruling today has exceeded." Then came the moment that would be replayed on news broadcasts for weeks to come. Crockett stepped away from the podium and walked directly to the center of the courtroom, standing perfectly straight as she addressed Breyer with quiet dignity. "I will not appeal this ruling, Justice Breyer." A murmur of shock rippled through the gallery. Her attorney half rose from his chair in apparent alarm. "I will not appeal," she repeated, "because I believe when you reflect on this moment, on the constitutional principles at stake, and on your own distinguished legacy of judicial wisdom, you will reconsider," she continued, her voice now carrying an emotional weight that seemed to fill the chamber. "I believe that the Justice Breyer who wrote about active liberty, who championed practical wisdom in constitutional interpretation, who understood the essential role of free and open debate in a democracy, that Justice Breyer will recognize that today's ruling does not reflect the constitutional principles you have dedicated your life to defending." Crockett's eyes never left Breyer's as she delivered her final statement. "And so, with profound respect for your service to this nation, I simply ask you to consider what this moment means, not just for me or for you, but for the Constitution. We have both sworn to protect." The silence that followed was absolute. For nearly a full minute, no one in the courtroom moved or spoke. Justice Breyer sat perfectly still, his expression impossible to read behind his glasses. Then, slowly, he removed them and placed them on the bench before him. When he finally spoke, his voice had lost all its earlier anger. "The court will take a 30-minute recess," he said quietly. Then, in an unprecedented break from judicial protocol, he added, "Representative Crockett, I would ask that you remain in the courtroom." As the gallery began to clear, those closest to the bench reported seeing something extraordinary. Tears forming in the eyes of the 80-year-old jurist who had spent decades on the nation's highest court. Whether they were tears of emotion, recognition, or regret, remained unclear, as Justice Breyer rose and disappeared into his chambers. The courtroom buzzed with anticipation. When the court reconvened 30 minutes later, the transformation was immediate and obvious. Justice Breyer returned to the bench, wearing a standard district court robe rather than his Supreme Court attire. His demeanor was markedly different, humble, reflective, and clearly emotional. Before delivering my revised ruling, he began, "I wish to address Representative Crockett directly." The courtroom fell silent once more as Breyer leaned forward, his voice now carrying a quality of genuine humility rarely heard from the federal bench. "Representative Crockett, your words have forced me to confront an uncomfortable truth. In my zeal to protect judicial authority, I failed to respect the constitutional boundaries that limit that very authority. Your willingness to stand on principle, even in the face of an unprecedented sanction, demonstrates a courage and commitment to constitutional values that I deeply admire." Breyer paused, visibly struggling with his emotions. "Throughout my judicial career, I have advocated for understanding the practical consequences of constitutional interpretation. Today, you reminded me of my own principles when I most needed to hear them." Then came the moment that would be described in legal textbooks for generations to come. Justice Stephen G. Breyer, who had served on the Supreme Court of the United States for nearly 3 decades, looked directly at Congresswoman Crockett and said, "I was wrong." The confidentiality order, as applied to a member of Congress discussing general statistical information relevant to pending legislation, exceeded this court's constitutional authority. The sanction imposed was not only disproportionate, but reflected an error in constitutional judgment that I now recognize and sincerely regret. A single tear tracked down the justice's cheek as he continued, This court hereby vacates both the sanction and the portion of the confidentiality order that restricts the speech of members of Congress on matters of public policy. The First Amendment and the speech or debate clause demand no less. The gallery remained completely silent, witnessing a moment of judicial humility virtually unprecedented in American legal history. Justice Breyer wasn't simply reducing a fine or modifying his ruling. He was publicly acknowledging a fundamental constitutional error and correcting it in real time. Representative Crockett, he concluded, his voice now steady despite the emotion visible on his face, your commitment to constitutional principle, even at potential personal cost, represents the highest traditions of both the legal profession and public service. This court stands adjourned. As Justice Breyer rose to leave the bench, something extraordinary happened. Without prompting or coordination, everyone in the courtroom, prosecutors, defense attorneys, court staff, journalists, and observers, in unified respect not just for the traditional adjournment, but in recognition of a profound moment of constitutional redemption. Within minutes of the court's adjournment, the extraordinary confrontation between Justice Breyer and Congresswoman Crockett dominated headlines across the country. Video clips of Crockett's principled stand and Breyer's emotional reversal spread across social media platforms with unprecedented speed, drawing attention from legal scholars, political commentators, and ordinary citizens alike. The Washington Post's banner headline captured the historic significance: Constitutional Conscience. How Crockett's courage led to Breyer's remarkable reversal. The New York Times followed with moment of constitutional clarity. Breyer acknowledges limits on judicial power. Even outlets typically divided by partisan perspectives found rare common ground in recognizing the profound importance of what had transpired. Legal scholars from across the ideological spectrum weighed in with analysis that transcended typical political divisions. Harvard law professor Lawrence Tribe called it a defining moment in the modern understanding of separation of powers, while conservative legal scholar Jonathan Turley described it as a rare and valuable instance of constitutional humility. From the bench, the American Bar Association convened an emergency panel discussion featuring former federal judges, constitutional scholars, and civil liberties experts. The consensus that emerged was remarkable. While courts maintain essential authority to manage proceedings through appropriate orders, the Constitution places clear limits on judicial power to restrict the speech of elected representatives discussing matters of public policy relevant to their legislative duties. For Justice Breyer, the aftermath brought both professional re-examination and personal redemption. 3 days after the hearing, he took the unprecedented step of publishing an essay in the Harvard Law Review titled Constitutional Humility: Reflections on Judicial Limits and Legislative Speech. The deeply personal piece became instantly required reading in law schools nationwide. Throughout my judicial career, Breyer wrote, I have advocated understanding the practical consequences of constitutional interpretation. Yet in that moment on the bench, I temporarily lost sight of the most fundamental practical consequence of all, what happens to our constitutional system when one branch attempts to silence another. He continued, Representative Crockett's principled stand forced me to confront not just a legal error in my ruling, but something more personal: how even those of us who have spent decades studying constitutional boundaries can, in moments of frustration or concern, lose sight of the very principles we have sworn to uphold. The essay concluded with a paragraph that would be quoted in constitutional law classes for years to come. Judicial authority, while essential to our constitutional system, derives its legitimacy not from power, but from restraint, the willingness to recognize and respect the boundaries that the Constitution places around each branch of government. When a judge exceeds those boundaries, it is not defiance, but devotion to constitutional principle that demands correction. For Congresswoman Crockett, the confrontation elevated her national profile in ways that transcended typical partisan politics. Constitutional experts from both conservative and progressive backgrounds sought her perspective on judicial limits and legislative speech. Law schools invited her to speak on panels addressing separation of powers. The Congressional Black Caucus unanimously elected her to lead a new special Committee on Constitutional Safeguards for Representative Democracy. Perhaps most significantly, the incident transformed the ongoing debate about voting rights. had been portrayed in some quarters as merely partisan, disagreement was increasingly recognized as a fundamental constitutional question about democratic participation. Crockett's measured, principled defense of her right to discuss voting access statistics reframed the national conversation around constitutional values rather than political advantage. 6 months after the confrontation, Justice Breyer and Congresswoman Crockett appeared together at Georgetown Law School's annual Constitutional Conference. Their joint presentation, titled Constitutional Dialogue: The Essential Tension Between Judicial Authority and Legislative Speech, drew an overflow crowd of students, faculty, and legal professionals. During this remarkable discussion, Breyer acknowledged that the confrontation had prompted deep personal reflection. "Throughout my career," he admitted, "I've worried about declining respect for judicial authority. But Representative Crockett helped me recognize that respect for the judiciary ultimately depends on judges, respecting constitutional limits, on our own power." Crockett, in turn, spoke about the courage required to stand on principle, even when facing overwhelming authority. "In that courtroom," she reflected, "I wasn't simply defending my right to speak as a congresswoman. I was defending the constitutional principle that no branch of government can silence another, principle essential to the functioning of our democracy." Their conversation modeled a form of constitutional dialogue rarely seen in an era of increasing polarization, one based on mutual respect, principled disagreement, and shared commitment to constitutional values. Law students in attendance described it as transformative, with one noting, "Seeing these two brilliant legal minds acknowledge both the tensions and the essential interdependence in our constitutional system gave me hope for the future of American law." The most lasting impact came in the form of a new judicial doctrine that emerged from the confrontation. In subsequent cases involving tensions between judicial orders and legislative speech, courts across the country cited what became known as the Breyer-Crockett principle. The recognition that while courts maintain authority to manage proceedings, this authority cannot constitutionally extend to restricting members of Congress from discussing general policy matters relevant to their legislative responsibilities. The Supreme Court ultimately codified this principle in a unanimous opinion written by Chief Justice Roberts, who cited both Breyer's Harvard Law Review essay and transcripts from the historic confrontation. "When constitutional tensions arise between branches of government," Roberts wrote, "resolution must be guided not by assertions of power but by mutual recognition of constitutional boundaries and responsibilities." 1 year after the confrontation, a survey of law professors ranked it among the most significant constitutional moments of the 21st century, not because of the conflict it initially represented, but because of how it modeled constitutional resolution through principle rather than power. For ordinary Americans who had witnessed the extraordinary exchange in media coverage, the confrontation provided a rare and valuable civics lesson about how the Constitution works in practice. It demonstrated that constitutional governance depends not just on formal checks and balances, but on the willingness of public servants to recognize when principles must transcend position. As one high school civics teacher in Ohio told her students, while showing video of the confrontation, "This is what the Constitution looks like when it's working not perfect people, but people committed to principles greater than themselves, willing to stand for those principles or acknowledge when they've fallen short of them." The story of how Jasmine Crockett's principled response made Stephen Breyer cry wasn't ultimately about emotion, but about constitutional redemption. A powerful reminder that, in a system founded on constitutional principles rather than personal authority, the greatest strength sometimes lies in the willingness to acknowledge constitutional limits, even when those limits constrain our own power. Please like and subscribe to our channel for more videos that explore the pivotal moments shaping American democracy. Hit the notification bell to ensure you never miss our latest content examining the constitutional conversations that matter most to our nation's future.